in Madura was that a presidential order was issued, because if you see the provisions of Article 366,
Yes.
22, as it stood prior to the amendment by the 26th Amendment. If you have this red book, it may not be in that. You will have to get it in the red book at page 372.
Yes, I'll just.
That said, ruler in relation to an Indian state means the prince, chief, or other person by whom any such covenant or agreement as is referred to in clause 1 of Article 291 was entered into, and who, for the time being, is recognized by the president as the ruler of the state, and includes any person who, for the time being, is recognized by the president as a successor of such ruler.
Yes.
Now, what happened there was, initially, after the proposed amendment didn't pass muster in the Rajya Sabha, a presidential order is issued, purportedly under clause 22. And the object was, now we are de-recognizing you. If you are being de-recognized, you lose the benefit of your privy purse in Article 291. That
presumed to be the consequence of de-recognition.
Right. So this was done in exercise of the power which was conferred under clause 22 as it then stood prior to the 26th Amendment. Our court said, look, by recourse to a presidential order, you cannot override a substantive provision of the Constitution, namely Article 291 and Article 362. That was Madhura's India.
Correct.
Then came the Constitutional Amendment, which was upheld against the challenge on the ground of the basic structure violation. Argument in this case is that what you have done essentially here is worse, because there was a presidential order in exercise of a provision in Article 366, which gave the president the power to recognize or de-recognize a ruler. Here what is being done is that 367 itself is sought to be amended in exercise of the, during the, we've seen
Operating
the modality.
370.
To amend 370.
Which has been done consistently and affirmed by your lordships. Well, the distinction is twofold distinction. A, 370 is the only article, was the only article which permitted the president to change any other article. So 367, your lordships have shown, I have shown the chart, that 367 mechanism was used in past. That has been the convention. So the only thing which happened, my lord, on 5th and 6th of August was that using the mechanism of 367, the Constituent Assembly was changed. It is not worst. There, my lord, there is a...
The 367 mechanism which was used earlier to, for instance, substitute, the Sadari Riyasat, etc., that was with the concurrence of the Assembly.
No. Only once. That was 370 sub-article 3. This, my lord, use of 367 is, kindly, my lord, see the distinction. What was done with the concurrence was under 370 sub-article 3. Constituent Assembly was there in 1952. It recommended and a change was made. This time, it is under 371D. That, my lord, would answer my lord's query, my lord, to my lord's satisfaction. Your lordships may come to, I'll show only two provisions, my lord. 371D. Your lordships have 371D, my lords.
Yes.
This is the first power. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Correct, my lords? Now read 3. Kindly read 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. That is first part. Or shall be operative only with such exceptions and modifications and from such date as he may specify. This is the power of extinguishing or partly extinguishing. So now this is crucial, my lord, apropos my lord's question.
Yes.
The first exercise, as your lordships have rightly said, was under 3. Because the Constituent Assembly was in existence, it recommended. Rest, whenever there were modifications made in 367, were made under 1D. All rest, all under 1D, including this one.
With the concurrence of the government.
Concurrence of the government.
The reason for that was very simple, because you are amending the constitution and you are not dealing with subclause 3 of,
3, yes.
you're not dealing with subclause 3.
I'm not dealing. I dealt with at the end on, my lord, 6th of August.
Because subclause 3 only deals with 370 itself.
Itself, not other, your lordships are right, not other part of the Constitution.
Because D refers to other provisions, because before D you have C.
Yes.
C says that the provisions of Article 1 and of Article 370 shall apply to the
Yes.
state of Jammu and Kashmir.
Correct.
Therefore, in that sense, it freezes the provisions of Article 370 in relation to the state of Jammu and Kashmir. Now, what it does is, therefore, it says other provisions of the Constitution shall apply subject to such exceptions and modifications. Therefore, other provisions will mean provisions other than Article 1 and Article 370
And 370 itself.
and 370 itself.
Correct.
Therefore, if you have to make an alteration of 370 or abrogate its status or reduce it or dilute it or alter it, you have to follow
Three.
equals to 3,
Correct, Manoj.
right?
But, my lord, kindly, I'm sorry, my lord, I'm almost reaching, my lord, at your lordship's level.
But then
No.
can you do that? Can you do
Exactly,
that
that's what I'm
using
answering.
the power under 367 then? That's the point.
Exactly, that's what I'm answering. I cannot do that under sub-article 3. 367, I cannot modify under 3 sub-article D. That I can do and I have done only under 371D. It has been used as a mechanism and Damnu approves it. Any-
Right, we've seen Damnu.
Any-
We are now just looking at it, we are looking at it as a matter of first impression.
Correct, my lord. The first impression.
Can you alter the import of a provision of Article 370 itself by a process other than 3? Because what you
No.
have done essentially here is
No, no.
that you have used 367 to amend the proviso to 370.
Correct. No, not amend. 367 is explanation. That instead of A, it would be B. It may have an effect of amendment.
Whether you call it an explanation or an amendment,
Yes.
one thing is very clear, that the amendment to 367 has the consequence of now reading the words Legislative Assembly in place of Constituent Assembly.
Which in fact was not necessary, but yes, it was done, but not under 370. It was done under the first step was, my lord, the first step was the President under 371D added the explanation that henceforth,
What the question being put to you is slightly, I think, different. The question is, by making the amendment in 366, by equating Constituent Assembly with the Legislative Assembly, aren't you in fact amending Article 370? Why, without taking recourse
To 373.
to clause 3 of 370 because Article 370 can be only amended in terms of clause.
Clause 3.
I understand. But then, my lord, it has the effect of it becoming permanent. Because there is no constituent assembly. So it can never be modified. 370 can never be modified.
Can take recourse. I mean, the argument on the other side is this, that you can take recourse to clause D of subclause D of clause 1 in a situation where you have to amend any other provision of the Constitution other than Article 370.
Lord, how?
But can you take, yes,
It doesn't say so.
It's very clear. It says
Such
of
other
the
provisions.
Other provisions of this
Other means except 1 and 370.
So you are saying such other
Yes.
provisions will include 367. Mr. Solicitor.
Yes, it's
All admissible responsibility. That doesn't matter. Let's not.
Quite often. I think I should be accustomed to Malad.
We are posing
Yes.
an issue because we have to deal with these issues. So we want to elicit a response.
Yes,
371D refers to other provisions of the Constitution. Other provisions of the Constitution, according to you, would include 367. Possible. We're not ruling this out at all. We will test that hypothesis. But can you use 367 and amend 367 to bring about an amendment to 370? If you do that while exercising the power under 371D, then are you not really doing that to amend 370 itself? Because the only provision which the Constitution creates to amend 370 is 370 clause 3. What you are now doing is, according to them, is that you are using the amendment of 367, applying the provisions of 371D to bring about an amendment to 370 itself. Whereas the purpose of 371D is to amend some other provision of the Constitution. True, 367 is another provision of the Constitution, but can you use that to amend then 370 itself? That's the point which you have to answer.
Lord, I can assure my learned senior.
No, please.
No, I can assure him, nobody can disturb me or derail me without my consent. I'm quite accustomed to such interruptions.
No, Mr. Solicitor, please don't get derailed because this is the heart of the matter.
No, I know that. My lord. And he also knows. But I'm quite accustomed.
Some clarity on this is necessary.
Yes.
Let's sit down and do it for
What
5
will
minutes
be,
and then
Lord,
we
I
are
will
through with
put
this
it
part.
slightly differently. I'll put it differently. The interpretation which your lordships are, my lord, prima facie now testing.
We're testing it.
No, we are testing it. The prima facie testing it. Lord, what will be the impact of that interpretation? I'll read, my lord, the entire Article 370. Meaning thereby, my lord, in absence of a constituent assembly, which can never be modified, the sub-article 3 can never come into effect, come into operation, and 370 gets the status of a permanent provision. Lord, please read it in totality. My lord, please read the entire article. My lord, for my satisfaction, please have a look at, my lord, the entire article. Notwithstanding anything in this constitution, your lordships can skip. The power of parliament to make laws for the said state shall be limited to those matters in the union list and concurrent list. Your lordships have seen, my lord, those the precedent here.
Instrument of accession.
The provisions of Article 1 and of this article shall apply in relation to that state. The purpose is that Jammu and Kashmir can do nothing in their constitution, or even Parliament can do nothing in their constitution. Kindly appreciate, my lord. The difficulty, my lord, if your lordships accept that, then even 368 route, which is the second route suggested, cannot be done. Because it says 1 and this article shall remain. If that is the meaning given, that is completely unalterable, then 370 remains as a permanent, though there are a host of considerations for me to show that it has always been a temporary feature. Further, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. My lord, other provisions would mean other than B.
Yeah, just stopping you for a minute. Could the Legislative Assembly make a recommendation in terms of 371A saying that under 367, you equate Constituent Assembly with Legislative Assembly?
Under 371,
What D? 370, sub clause 1, subclause D. Could the Legislative Assembly make a recommendation saying,
if it is amendment, it cannot. If it,
just think about it and then answer. Could the Legislative Assembly make a recommendation to the Parliament, please amend Article 367 and
well,
equate.
let me give it a thought and my lord respond to that. My lord, that I understand the heart of the matter. Your lordship's lord discussion, my lord, is driving that any 367 use which has the impact of altering 370 itself, my lord, then my lord, we would be setting at not all 367 usages. My lord. But kindly remember, through the 367 mechanism, 370 has been modified.
That's the point in favor of what you are saying, with the caveat that the use of the 367 mechanism to modify 370 was always with the consent. Sorry, consent.
Here also it is concurrence. The only difference.
It was concurrent.
Yes,
That's
this is
the very one. That is constitutionally the significant difference.
But this
Now,
is
what
also
we
with
have to
concurrence.
see.
Look, this is also with concurrence. The only difference is the concurrence of the governor, because governor steps into the shoes of the government.
So there's a difference between concurrence and recommendation.
Correct. But
Concurrence
for
can be subsequent, recommendation has to be.
the recommendation is of the body, Constituent Assembly as it stood, and subsequently, if we are right, Legislative Assembly. Concurrence of the government. Please see, my lord. And government, the only dispute was that government cannot mean governor. Please see, my lord, concurrence provision, second provision.
Concurrence of the government means that Council of Ministers.
Council of Ministers, if it is there, otherwise powers are exercised by the governor. And that's why, my lord, I pointed out that there are several exercise of 371D when there was a precedence rule with concurrence of the governor.
At least you have provided yesterday.
At least,
At least you have read it yesterday.
yes. Yeah, my lord, your lordship.
Provided yesterday.
At least,
At least you have read it yesterday.
yes. Yeah, my lord, your lordship's query is, my lord, absolutely, my lord, dot on the point. But, my lord, I'll respond, my lord. Let me give it a thought. But the real question would be,
You have already responded.
well, the real question is, my lord, that here concurrence is that of the governor. Government, whichever is the government, if it is ministry, then cabinet, aid and advice, otherwise the governor. And during governor's rule, 371D is used to change 367 also. To not change is a incorrect word I have. To put an explanation, to give meaning to 370.
So simply put, according to you, at a time when there was no legislative assembly, the explanation was amended so as to incorporate
Democratize.
so as to provide that the Constituent Assembly shall itself be treated as the Legislative Assembly.
Because it was so treated
Because the
early.
Constitution had not been framed and there was no Legislative Assembly in the state of Jammu and Kashmir. So according to you, the flip side now is that when there is no Constituent Assembly, we treat the Legislative Assembly as a Constituent Assembly.
To democratize, my lord. Otherwise, my lord, kindly see, suppose the government took the decision. The government took the decision, my lord, suppose.
The second answer could be, and that's for the other side to answer, by amending 367, in fact, you're not really amending 370 as such, because the 370 procedure has to be still applied to abrogate or nullify 370. The procedure has to be still applied. Suppose 367 had been amended in terms of 371D with the concurrence of the state government. Second step, the Legislative Assembly had made a recommendation, please abandon or abrogate 370. It would have passed muster. Nobody would have really, probably the other side wouldn't have been here also, except some of them.
Yeah, they would still be here, but that's beside the point.
But it could have been done. If this route is permissible or not.
Lord, suppose I'm putting a question to myself. Lord, suppose
I thought I answered it in your favor.
Your Lordships are absolutely right. That's my answer, my Lord. That's my answer. I'm grateful to your Lordship, my Lord, for that. That thought didn't occur to me. But, Lord, suppose we took the decision that in view of the proviso becoming otious, because there is no constituent assembly, that limitation of recommendation, ultimately it's recommendation. Suppose it recommends that don't abrogate. President is not bound by it. So, now the Constituent Assembly, having chosen while being dissolved not to recommend, the Constituent Assembly has left it to the absolute discretion of the President. It could have been done, my Lord. Possibly it could have been defendable action, but with a view to ensure that there is democratization of the action. And my Lord, your Lordships are dealing with the state of, this is a provision which is one of its kind. There is no such provision either in our constitution or in any constitution. So the law which your Lordships would ultimately lay down is not going to, Lord, touch upon any other provision. If suppose the Constituent Assembly, while it was being dissolved, if it framed the constitution, it had options. A, don't abolish. I am recommending that President should not exercise powers under sub-article 3. He should not abrogate 370. That was the first option. Second option, he should abrogate Article 370 after 5 years. Till then, let the Constitution continue. Third, the President is, we recommend that President should modify some of the provisions which we recommend and continue 370 as it is forever. Having done nothing of this, the Constituent Assembly goes without making any recommendation and therefore leaving it to the absolute discretion of the President.
The Solicitor, you said that the President is recommendation.
It's a recommendation, my Lord. It's not.
You see the words used in the proviso. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary.
Yes, Lord. Why I say this, Lord, kindly see the second proviso, where concurrence word is used. Concurrence means I have to say yes, otherwise you cannot do it. Therefore, I am contrasting the word concurrence with recommendation. Consultation, yes, the concurrence is at the highest level. That without consent, concurrence means consent. Consultation may sometimes means consent, may not mean consent. Your Lordship has seen Justice S.H. State's transfer of judge's judgment, where it says that consultation can even mean concurrence. So I am not just contrasting the word concurrence with recommendation, that the same provision uses the word concurrence, means unless the state say yes, President can do nothing. But here same provision uses the word recommendation, that you will recommend. Ultimate power with the President who is answerable to the House which is answerable to we the people of India. So highest executive functionary is conferred with this decision, and we can read that in absence of Constituent Assembly and its recommendation, the proviso goes. It becomes redundant. It becomes otious. It becomes not possible of being implemented. And law doesn't require performance of an impossibility. But considering the nature of the strategic importance of the state, it was felt necessary that let this be debated in both the houses of parliament. And Rajya Sabha is, my lord, house of people. It has its own federal structure. Every state has a representation in a different indirect election form. And both houses passes, my lord, with 2/3 majority.